wisdom. I wish we had more time, but I do want to introduce Zen and Scott, two wonderful and highly talented people. Zen I've gotten to know personally. One of the reasons we bring them in is because much of what you do is edge science, and there's a lot of innovation there. And the university has an interest in protecting the IP that you generate. And I think it's also in your interest, because increasingly universities are monetizing, and your value will be determined, your value add to the university is determined by the innovation and the monies that you can bring in. So I will have Zen and Scott talk to us about that. Zen?
Thanks, Vivek. Thanks for having me and Scott. I think I was introduced in an earlier session, so we won't waste time on that, but I would love to have the chance to introduce you all to Scott Kamholz. He's an old friend of mine. He's a physician, PhD, and a doctor, and a former USPTO patent judge. So he has a wealth of experience, much more than I do, in terms of seeing the birth of intellectual property, coaching inventors along the journey, and out licensing out of universities, and and seeing those things. And so we're going to rely on his pattern recognition today, and I'll chime in with other stuff. So I'll start it off with and I think we'll talk for minutes, and then wide open to questions, because I'm sure the specifics and what you may think of as burning needs to figure out your patents or licenses as inventors or entrepreneurs. So Scott, give us a flavor for how you counsel early inventors who are at universities or academic institutions.
I've handled that actually several times. Usually as the counsel for the university, they will bring me in as an external person to handle the patent filing. But I have handled a few times the issue where an investigator is forming a company as a founder. And then there's a sort of a triangulation process to get the necessary intellectual property into the company. It may seem kind of silly, but one of the most important things in this process is education, making sure that everybody understands what a patent is and what a patent isn't, what it can do for you and what it can't do, and the role that it plays in setting up companies and moving them along the product development process and eventually into marketing and making money. And the funny thing is that in some sense, the patent is not terribly important there. Getting that initial intellectual property issued as a patent is not really its function. The real intellectual property often comes down the road once the company has taken the fundamental insight from the investigator and found the direction in which it's going to go. So that initial IP that's generated from the university and sort of seeds the company is more of a transactional token, if you will. It is a
stake in the ground.
Exactly. It is saying this is the company with which we have entrusted the initial responsibility for developing this technology and figuring out where it will go.
Right.
And of course, then there are competing tensions there, because oftentimes what ends up being the product that the company will launch doesn't necessarily involve everything that came out of the university, from the investigator's lab. It will be focusing on something narrow. And so then there's going to be negotiations about what exactly are the rights that the university is going to give to the company? What rights does the company need? Where is the investigator in all this? I mean, an investigator in this position is wearing at least 3 hats, right? I mean, they're an employee of the institution. They are an employee or an advisor or a consultant to the company. And then they're also an individual with their own goals and dreams. The short answer is everybody has to get a lawyer.
Yeah. Well, but you point out the right kind of thinking, which is, you have an early phase where you're putting a stake in the ground, where you're out licensing maybe the initial technology. And that's really where you have the most leverage to negotiate with the university, who, I think in my experience, and this is not hitting on any one university, but I've out licensed from Harvard and from MIT and from Yale and others, not UCLA. I never successfully UCLA, although I tried, but it was, and this is the basis of some of my comments, the tech licensing offices are often the biggest barrier to getting innovations out into the world, even though they think they're doing their job. And so then the challenge is for you as an inventor, especially for inventors, because you have the most leverage as an inventor of that patent. They have an obligation to help you, but then you jump to the other side of the table and they're trying to give you a very narrow license of a field of use, as opposed to maybe the entire patent for all uses. And as an entrepreneur, you want that wiggle room. And so, tell us about kind of how do you see the early phase versus later phase in terms of negotiating leverage on the part of the inventor?
No, I agree with you. The inventor has the most leverage earliest in the process, in my view and in my experience, precisely because the direction the technology will go in has not yet been defined. And also because the cost to the university so far has been small. You think about filing the first patent application, we might be $10,000 to $20,000 in. At that point, the university is looking to recover that investment. And so they will be willing to accept more modest financial terms in order to recover those losses or those investments and the expenses going forward in maintaining the patents. And because you don't know the direction the technology is going in, they're more likely to grant a more global type of license, a license that covers any direction that technology may go in. Particular disease indications or particular populations or particular modalities in which the invention is practiced, geographies, fiscal terms, reporting obligations, renegotiation periods, there are many different axes on which you can fashion these agreements. And everything is just easier at the beginning because it's nebulous and because the value hasn't been defined.
Because the cost that they're trying to recoup is fairly low relative to what happens at the 30-month mark. So maybe it would be helpful to describe when patent costs really start to blow up when you're trying to file in multiple countries outside the US.
It is important, and I've especially had to counsel my individual inventor clients in this reality, which is filing that first application is sort of putting yourself on a moving walkway that you can't stop except by jumping off it completely. So you file that first application. Maybe some people on the call have heard of a provisional patent application. Provisional patent application has a lifetime of 12 months. At the end of that 12 months, you've got to decide whether you're going to go on with it or let it expire. If you go on with it, you have to then decide, are you going to pursue it in the United States only, or are you going to pursue it outside the United States, or both? If you're going to do both, then there is a mechanism called an international patent application. That's going to be roughly double the expense of the provisional patent application. And then, so now we're 1 year in, and we are probably up to $40,000 of investment. And then a year and a half after that, the 30 months from the very beginning that you mentioned, Zen, you have to decide whether you're going to take that international patent application into any particular countries. At that point, the expense explodes because each country is going to charge $5,000, $10,000, sometimes $15,000 to make that initial filing. It includes translation costs and fees from international lawyers all over the world. And so that initial filing, it might be $10,000, but you're committing yourself to over $100,000 of patent expenses in the next few years. And unless you have a plan, unless you have developed,
that's pretty conservative That's pretty conservative in my experience for some of these biotech patents where
we're not talking
doing
biotech.
Translation fees.
Right. And for the company, I until recently was head of IP for a biotech startup in the Boston area, focusing on genomic engineering. I'm now an independent IP consultant, and I work with clients of all sizes everywhere. But as head of IP for that company, yes, we had days on which we filed patent applications that in one fell swoop incurred $500,000 of charges.
Right.
But at that point, the company has got the resources to pay those
Right.
things. That's not really the issue. We do, however, face issues like that in maintaining our university licenses, where my company paid all of those expenses. And at that point, we had begun to define the particular product that the company would be focusing on. And so our licenses began to have things like milestones for the development, approval, and launch of a particular therapy that carries much larger price tags. And those negotiations, because they involve millions, tens of millions, sometimes hundreds of millions of dollars, the negotiations are very, very deep and intense. We're not talking anything like that now. The initial.
Yes. Okay. You can spend as much as you can afford. You clearly need good patent counsel to help you think as an inventor, but also as an entrepreneur through the process, and really match the goals to your resources. And especially if it's an incredibly hot, active, noisy environment. I've been recently working with one of my startups around AI and machine learning, and it is, half of all the 360,000 patents that have been filed since the 50s have been filed in the last 10 years, right? So that added noise makes it very challenging to figure out what you should and can get and what is really strategic in the company. So that boils over into some of the software strategies, and we could do an all-day session on this, but why don't we open it up to questions? And Scott has graciously said he would give his email out, and happy to follow up with interested folks if you have detailed questions. And you don't need to describe a secret sauce here in what may be considered a public forum, but I'm happy to answer. Scott, for that.
I'm happy to answer one-on-one questions. And a big part of my practice over the years has been giving frank and realistic advice to investigators to help them decide whether it's worth proceeding. I'll give sort of an unrelated example. One of my clients invented a surgical method, not a tool, just a surgical method, a potentially very interesting surgical method for rotator cuff repair. And I had to counsel that person that although you might be able to get a patent on that, it's totally unenforceable in the United States. There is actually a federal law that says you cannot enforce a patent on a method of medical treatment against a practitioner. And since there's no special medical device or drug or something that some company would get involved in marketing, there's no one to sue on that patent. Therefore, no one will pay for it. That's a very simple example, but helping people ground themselves in how to proceed with IP is something that I've done for 20 years and continue to enjoy doing. But oftentimes the answer is don't bother. Or we will often do a pre-patent filing search. Like I will hire somebody who's very good at searching, and we will do a search and get an answer as to whether there's anything left to patent in a busy space. Right. Or I have those tough conversations about a business plan. Many people have the notion that the act of filing a patent application, maybe even obtaining the patent, will cause people to come to you to license that patent and build a company. And my experience is that's not how it works. You've got to fight. You've got to create the company and the opportunity. And so without a business plan, a patent is essentially worthless.
The only time you
Yeah.
Oh, go ahead,
Zen,
Vivek.
if I may, let me go upstream and say I'm a junior faculty. I'm approached by, say, Google, and they want to work with me. And then there is this whole flurry of all. How do I go about connecting with the IP team in my university?
Most universities have, of course, there's a technology transfer department, and that's where the intellectual property specialists live. Every university, every academic institution I've encountered has an invention disclosure policy with a form typically one fills out. If anybody has been following the CRISPR-Cas saga at the patent office, recently the very initial invention disclosure form from the Broad Institute for CRISPR-Cas was made part of the record. And so you can, if you want to see a famous invention disclosure, you can go look at that case and view it. But that form is the way of officially notifying the intellectual property community at your institution that you've got something. And then typically the ball is in their court to talk with you, understand the invention more, make a decision about whether the university wishes to pursue the technology. Sometimes the university, since the budgets are limited, they will make the call not to file a patent application and let some of the rights revert to the investigator, who may then choose to take it outside the university completely. But the Technology Transfer Office or the Innovation Center or the Commercialization, Zen can give the other synonyms for that office, but those are the sorts of people who get involved. Look for an invention disclosure form on your website, and that will be the first step.
Well, and I think it's important to say, you know, having been a tech transfer officer at Harvard Medical School myself, it is a challenge, right? They're dealing with limited resources. They're in service to especially the tenured faculty, but really all faculty. But you know, the high-profile inventors on campus end up being serviced more than the junior faculty. And so, as a junior faculty, oftentimes folks get frustrated having to market themselves and really, you know, get attention from a limited number of tech transfer officers, and you know, what you can do to improve your odds and to improve their interest is really to sit down and describe in your disclosure form the why this is important, why this is big, why this is economically impactful. And that ends up being really the nuts and bolts of a business plan for how many patients you can affect and what the value of that disease is today. And so even just a little bit of market research and quoting others' market research can give you ammunition and give the tech transfer officer ammunition.
That's right, because the tech transfer office is not just patent attorneys. In fact, oftentimes they don't even have someone who's a true patent attorney, but these are people who know how to conduct research into the market and can give you pretty plain advice, because they have to make that analysis to decide whether your invention is worthy of an investment. They have to make a value judgment. And in fact, I remember pitching inventions to Zen, and he very politely listened to them and then calmly explained why there was zero market, or certainly not enough market to justify an investment. I still remember one, I think that would have changed the world, but you know, I trust Zen's judgment to have been there already and you know, to have been through that process and know the realities. So that office is a wealth of information. On the other hand, I worked with at least one inventor who went out of his way to make his inventions difficult to understand. I mean, he would typically present them as a series of surface integrals and partial differential equations. And this is my invention. The tech transfer office could not make head nor tail of it, and they released the rights, and then he went on to really describe it carefully and accurately in a series of patents from which he made millions of dollars. I do not advocate that approach. I think in most circumstances, the tech transfer office is your best resource for evaluating a market opportunity.
And certainly a hurdle that you have to get through if you are, bound under obligations of an academic institution or a clinical institution.
I imagine every investigator on this call is bound by those obligations. So yes, you in fact do have to go through the tech office as the first step. But ultimately, they are. I mean, I know from my negotiations with tech transfer offices that they're first and foremost interested in recovering their outlay, the initial outlay for the patent applications. Number two, they are very concerned with preserving the investigator's right to publish their work with minimal restrictions imposed by a company. And I'll tell you that they really do care about that. That is a term that is essentially non-negotiable in university licenses agreements, the investigator's freedom to publish. The other thing that they care very much about is exclusivity, meaning a company will pay very much more money for exclusive access to some chunk of the technology. The university is hesitant to give that out because that means they can only do it once. And so if they're going to give exclusivity, it's going to be in a narrow field. And so the company has to decide, do they really want to hone in on one area and totally control it? Or do they want to have non-exclusive access to a much wider field?
Well, that opens up an interesting thing that I've seen play out in a number of ways, especially in software patents, where an inventor, a faculty inventor at a university, really wants to just get it out there and get it used. They would prefer to give non-exclusive licenses to a whole range of large companies, but then they don't understand the fact that companies need those investors in those companies want and need exclusive licenses. And so then you end up parsing by field of use. Maybe you can walk us through some of that.
Well, we're a little short on time there, but maybe a very good example to maybe slightly adjacent to that point is the timing of publications and the filing of patent applications. Because of course, if the publication comes out before the patent filing, then there's no talk about exclusivity or non-exclusivity. It's open and free to use by everyone. I have had several experiences with tech offices that were not careful about coordinating publication and patent filing. So as an investigator who is looking at founding a company to develop a technology, it becomes important for you to make sure that the tech office is handling that timing correctly to preserve ultimately the rights in the IP. But to address your question more specifically, of course, the exclusivity that a university gives to a particular company it's really just a question of the money involved. In my experience, the exclusivity will be at least 10 times more expensive than the non-exclusivity for a given range of a license. And so those numbers often drive what a company is willing to pay for exclusivity. And the real negotiating point then becomes less the money and more the scope. You're fighting for access to all human diseases or one particular human disease or one particular geography.
Manish has a question.
There is one question in the chat. Oh, go ahead, Vivek.
No, I was going to point you. Go ahead.
Okay. There is, one question from the chat is, if you make a new innovation open source, are you protected from someone filing a patent on that innovation or modifying it in any way?
More or less, yes. If you publish it, if it's out there in the public, then somebody who later files a patent application that covers that cannot get the patent. The patent office might miss your open source publication, but assuming that everyone has perfect information and acts on it perfectly, then that patent would be barred. What would not be barred is if somebody filed the patent application before the open source publication. And if that earlier patent application happened to cover some aspect of the open source project and a patent were obtained, then they could block the access to the open source. And patent applications don't get published for at least 18 months after they've been filed. So there's a year and a half lag in knowledge of what has been filed for. So it's quite possible that you publish an open source system that people are free to use, but 6 months before you publish that, somebody made the same invention and filed a patent application on it. And that because that's earlier in time, their patent could dominate. So it becomes a task of getting a patent attorney to do a search and to identify patents that may block. That's colloquially referred to as freedom to operate, which of course is a major part of my work.
Did that answer everything, Manish? Okay. All right. Well, let's see. We'll keep you guys on track unless there are other questions and we have extra time. But Vivek, lead us on.